The legal battle between President Cyril Ramaphosa and former President Jacob Zuma. As you've heard a little earlier, the High Court in Johannesburg will, in less than an hour, begin hearing Ramaphosa's application for an urgent interdict against Zuma. For some analysis, we're joined now by legal expert Nthabiseng Dubazana. Nthabiseng, good morning to you and Happy New Year. First time talking to you in 2023. Let's begin with whether this urgent court interdict by President Cyril Ramaphosa is necessary, given that he says he is not mentioned in that non-prosecution certificate that would have been obtained by former President Jacob Zuma. But add to that the summons, which he says, based on process, it's invalid. So does he have a reason to rush to court? And by the way, there's a full bench that is going to now listen to all of this.
Yeah. So let's firstly maybe look at how criminal court usually works. If in the instance that you are now being an accused person in the matter, and once we have received a copy of the docket, we realize that you are not actually part of the evidence that is within the copy of the docket. What usually happens is that your attorney of record would then make representations to the state and say that, listen, check your docket. From what we can see, our client is not implicated in this matter. Please then withdraw the matter, and then the state will then on the next appearance withdraw the matter. That is simply how it usually would work. In my opinion, I would have thought that if indeed there is no way where he's mentioned in the docket per se, not only on the non-prosecute certificate, but if the evidence that the private prosecution attorney has, he is not mentioned in that. Representations would have been made so that on the 19th, when they appear in court, there is a situation where the presiding officer would have to make a ruling whether or not to proceed with the evidence against President Ramaphosa based on the representations that were made that show that he is in no way part and parcel of the case before the court. Now, having said all of that, the purpose of an interdict is to stop something from happening, and then it is the part A part of an interdict, and then there's a part B. The part B is that in the event the court grants me my interdict, which is what I'm requesting in part A, then when part B does happen, then it can then be made final on the next court appearance, because it can't be an indefinite interdict at the end of the day. Yeah. So today, the court has to, one, look at the summons, like you've mentioned, whether the summons was correct in law, if there are any defects, are they so bad or such importance that the matter cannot proceed on the 19th. And then over and above that, I think there was an issue about the unconstitutionality of the actual proceedings that was raised in the papers President Ramaphosa. And then we are also looking at the non-prosecution certificate, whether it was supposed to specifically mention a name, or is it sufficient that there's a certificate that was issued on the matter and therefore granting President Zuma the right to proceed under private prosecution.
Yeah. Advocate Paul Hoffman has gone some distance this morning trying to explain to us why a full bench would sit over this matter. Put it plainly for us, someone like me who doesn't understand law, why would a full bench want to sit on this matter or preside over this matter? Is it to thwart what would come later as perhaps a form of an appeal? What is all of this necessary, basically, is the question.
Because this matter is is in its nature, it attracts a lot of public interest. I believe the DJP did not want the court to find itself lacking or wanting in considering the merits of the matter on both sides. So that is why the directive was put up that a full bench be sitting in this hearing, so that if there is a dissenting judgment, it can also be recorded. So it can be shown, it can be seen that the court is really applying its mind to the facts of the matter, the merits thereof. So when they go and deliberate on this matter, there is 3 different minds that are going to talk about this, and 3 different research analysts that are going to be part and parcel of this. It has to be such that even if where there is appeal that's going to happen, let's say that Ramaphosa wins this matter, and on that 19th he doesn't appear as a result of today's interdict, or today's hearing rather, then the grounds of appeal or the grounds of review would then be covered, in the sense that they would have applied their mind so extensually that it leaves no room for error. That is basically why the full bench is sitting today. Because remember, not all judges will always agree on something. There's always the majority judgment, there's always the dissenting minority judgment. And as a result, those things will help us see which way the courts were going and which other way could have happened should there be a dissenting judgment. But if all the presiding officers agree on the manner in which the decision should go through, then it shows that they were of one mind. And when you go on review, the likelihood of it going on review or an appeal will be slim to none, because they would have covered all their bases.
Thank you so much for explaining that to us so well. Perhaps a final question to you, and it's got to do with what this case is about. Former President Jacob Zuma says, you, Cyril, my successor, you did not act when I came to you to complain that a prosecutor who's prosecuting me on the Armsdale trial allegedly leaked information about my medical records to a journalist. So that is a separate matter. That's got to be debated as to whether indeed there is a case there to begin with. But where does the president fit into this picture where he is accused of not acting and therefore violating sections of the NPA Act?
I would love to know the answer to that question, because I would love to have the docket and see how the two are linked. Because remember, yes, the president is the head of state and all legislation and eventually gets signed by his hand, right? But the NPA has its own forum and how you deal with this. But that's why there's the DPP, the NDPP, all those people. Perhaps, if I were to just think out of the box here, perhaps the way that Ramaphosa is now being made to be an accessory after the fact is that as the head of state and of the NPA rather, he ought to have given instructions to the head of the NPA to say, listen, I've gotten this complaint directly. Please look into it and show that he was basically helping a citizen, not just somebody who's a successor from the person who's accusing him, helping a citizen to show them that, okay, we are trying to make sure that your privacy really was not violated as badly as you see it to have been done, and therefore this is what I have done to prevent all these things that have now led to this matter being where it is today. Mm-hmm. So maybe that is perhaps how they're linking the Ramaphosa to this matter, but without access to the docket, I can't give you a definitive answer as to how he became an accessory after the fact to the charges faced by Memon and Mr. Downer.
Yeah, perhaps on a separate issue, Nthabiseng Dubazana, and I'm sorry to surprise you with this particular one because you may not have prepared for it coming on air. It still involves former President Jacob Zuma. Remember that sometime last year, the Supreme Court of Appeal invalidated his medical parole, which means that the fact that he was arrested at some point and was actually sent physically to jail, that decision has now been invalidated. But then the court left it to the Commissioner of Correctional Services to say, you will determine whether or not, given that this parole is now invalidated, you make a decision about whether or not former President Jacob Zuma should go back to jail. Now, the former president has missed his deadline at the Constitutional Court to appeal this. What are the implications for him?
To be quite honest, that decision for me, from where I stand and from a legal standpoint, is now moot. Because that decision came after the sentence was done and dusted. Oh, My goodness, and we just got hit by load shedding. I hope I don't get cut. So that decision happened after the sentence was complete. You cannot now apply a sentence retrospectively because the judgment happened or was handed down rather after the time that was allocated for him to serve his sentence has come and gone. So him missing his constitutional deadline to appeal this matter for me is neither here nor there, because he in essence and literally has served his time. Should now the court say or instruct the commissioner to say, we know that we gave you a decision after the sentence had been done, but he still needs to go back and serve the time that he spent outside after he got medical parole. Now that would be setting a very dangerous precedent, because it will be used by the NPA and anybody who has now been on parole, and things that are happening that are not being done right and all of these things now is going to be applied to everybody else who is currently on parole, which is not a good thing. Mm-hmm. Your sentence doesn't apply. You can't repeat rather your sentence after it has been served, just because the court gave a ruling after the fact. For me, it really doesn't matter whether or not he takes it to constitutional court. His time has come and gone.
Nthabiseng Dubazana, thank you very much. And in the nick of time, before she got cut off there, load shedding, it is the bane of our existence in South Africa.